So, good morning, everybody, and welcome to this Amicus Curiae event on the EPSU case. First of all, I want to thank Philippe Dosserman that immediately supported the idea to organize an Amicus Curiae on the EPSU case. And I want as well to thank Katrien van der Linden and Fotius Brejanis that help us in the organization of this event. Organization that was not easy because we have to combine people that is present in the room and people that follow us from home using Microsoft Teams, sorry. The event was organized together with the 3 university foundation on European study, 3 European foundation based in Brussels, so the UCL, the ULB, and l'Université St. Louis, and was supported mainly by the Atelier des droits sociaux de l'Université catholique de Louvain. The idea behind the Amicus Curiae is to discuss, to open a debate with a court before the court decides on a certain case. This format has been developed in my university, the University of Ferrara, by Professor Roberto Bin, that is a professor in constitutional law, and he started this format in order to discuss with the Constitutional Court. So he thought, and it was a long time ago, that in several occasions the judges should take a difficult decision because these decisions are not fully debated, are new issues. And this is precisely the idea behind the Amicus Curiae. So the idea is to open a discussion on a topic that has not been fully debated yet, and to open a dialogue with a court that then has to decide on this topic. So this is the reason why we think that the EPSU case need an Amicus Curiae, because of course the court, the General Court first, and in future the European Court of Justice has to decide on a topic that was never decided before, so it's a new issue on which we need a debate. And this is the reason why we spread around colleagues, not only labor lawyer, but also expert in constitutional law and European Union law. We spread a call for speaker, and I have to say that we receive several abstract. We did not refuse any abstract because the idea behind the Amicus Curiae is really to open a free, open and transparent discussion on a certain topic. So I clearly want to underline that each speaker is fully free to present his or her opinion, and we don't want in any way to condition the court. The court is, there is no need to say the court is free to decide. What we want to do is just to collect opinion on this case, opinion that unfortunately are not there yet. Of course, we have comment of the decision of the General Court, but what we want to do is to exploit the debate, to go deep into the issues that are not fully discussed. So before starting, I just want to give you some technical recommendation. For people that is at home, please mute your microphone on Teams and if possible switch off the camera, because this facilitates the team debate, because if not we occupy the connection, so it can be that will be disturbed the connection. Of course, the speaker that are not here present in Brussels, they can switch on the camera and switch on the microphone when they speak. For the people present here in the room, you should also switch off the sound of your computer and the sound of Teams, because if not, it interferes with the connection that we are using. Another recommendation, we will open a discussion. We have a question time, 2 question times actually. The first one after the first part, and the second one at the end of our seminar. I will collect the question only via chat, so for people that is not present in the room, you can write me the question via chat. I will collect the question, and then I will ask the question to the speaker. And if you can also specify to whom your question is addressed. We kindly ask you to pose only short questions, because we don't have a lot of time. For people that is present in the room, you can raise your hand, ask question in a classical way. Of course, we need to have short questions so that everybody can speak.
We can't hear anything. We can't hear anything from Sylvia.
Sylvia, you're muted.
Sylvia is muted. It's muted. We can't hear you, Sylvia.
You have been muted for 15 minutes now.
They don't hear me, and
anybody put the microphone of Sylvia on in a way, because in this way is just useless.
On n'entend pas Sylvia.
That can be a strategy, but it was not. We are checking. Emma, I should keep the microphone mute on.
Now, yes.
Now.
For a while.
Okay, now can you hear me?
Yes.
Yes.
Okay, so what I said until now have been recorded. I can shortly repeat the conception behind the amicus curiae. So we want to open a transparent and fully open debate on a case that has not been approached before. And so we need to discuss this case. And I thank Philip Dosserman for the organization, and also Catherine van der Linden and Fotius Brejanis for helping us in the organization, and also thank all the institute that support this initiative. And I gave some recommendation in order to participate to this seminar. So for people that stay at home, for people that are not present here in the room, you should switch off the microphone, and the camera, because that helps us in supporting the connection. Of course, the speaker, when I will give you the floor, you can switch on the camera and your microphone. I will collect all the questions via chat. So please, if you want to ask a question, please write the question via chat. And also, if you can also specify the speaker to whom your question is addressed. Here in the room, people already listened to the technical recommendation, so I don't have to repeat the technical recommendation for the people in the room. And the last point, of course, we want to collect the paper that will be presented today. So I kindly ask the speaker to prepare a short paper, we think 4 or 5 pages maximum, because we will collect all this paper and we will send the paper to the European Court of Justice, and we will publish the paper on the working paper Massimo D'Antona of the University of Catania. And I really thank the University of Catania for immediately accepting our idea to publish the paper of the amicus curiae as a working paper Massimo D'Antona. So the paper will be available, freely available for everyone that is interested in reading what the speaker will present today. Okay. I think we can start. So the first person, the first speaker of our seminar is Professor Jacques Ziller of the University of Pavia. And I would say we'll start from the beginning and arrive directly to the end. So from the beginning, because the consultation concerned the central government administration, and arrive immediately to the end because it was precisely because the agreement concerned the central government administration that the agreement was rejected by the Commission. So, Professor Ziller, the floor is for you. Thank you very much.
Thank you very much. I will show you a PowerPoint which I've prepared, hoping everybody can see it. Could you confirm you see it?
No.
Not yet.
Not yet.
Technology is not all right. Do you see it now?
Yes, something
Yes.
is happening.
All right.
Yeah.
Thank you very much. So I'll speak about the notion of central government administration and the scope of European Union law. And I will develop 3 points. First, the relevance of this notion to the case we are discussing here. Second, the diversity in member state administration regarding functions and organization of central government. It's a point which has been brought by the Commission in its letter to EPSU when EPSU asked for the extension of the agreement. And third, member state administration and organizational autonomy and the applicability of EU law to central government administration. So to start with the relevance, I don't know if all the audience is familiar with the case C92819 EPSU, which is the appeal brought by EPSU on the judgment of the General Court. The point which I'm referring to is in the 4th ground of EPSU, where EPSU says that the reasons given in the letter from the Commission to EPSU were not the reasons relied on by the Commission in its defense or at the hearing. And the point which is central to my presentation is that those reasons were legally and factually misconceived. So the reasons presented by the Commission in its letter to EPSU relate to a number of issues which will be discussed later on during this meeting, especially on admissibility and on the discretion of the Commission. But the Commission was saying to EPSU in its letter that it would not ask the Council to extend the agreement by way of a directive because of the diversity of member state administration. And that's what I want to explain now. The functions of central government administration, to which the Commission was referring, saying that it notes that central government administration exercise the powers of a public authority, those functions are far more different than what would seem like this. The assumption, as far as I could understand, of the Commission in this case is that because the functions of central government administration are linked to the exercise of the powers of a public authority, it should not be dealt with in the same way as the rest of government and as the private sector. Well, if we take the central point, which is functions of central government administration, those functions are extremely diversified and are certainly not limited to the exercise of the powers of a public authority. In central administration, we'll see that there are a lot of different types of organizations, but there are also a lot of different types of functions. For instance, there are indeed functions linked to the exercise of powers of public authority when central administration decides on single cases or prepares policy notes or any kind of these things. But central administration is also simply managing organization. And as far as we know, management, even in the public sector, is not the exercise of powers of a public authority. That's the first point. Then, if it's true that in central government administration, there is very often, but not always, the exercise of powers of a public authority, also local and regional governments exercise powers of public authority. Just think about what we have been through and we are still going through with the pandemic, where a lot of decisions which have an impact on everyday life are taken not only by central government, but by regional government, by municipal government, etc., etc. So that's the first point. One should be aware that the functions of central government administration are certainly not limited to the exercise of the powers of a public authority. Now, why has the Commission in its letter, and as far as we've seen, it's not been discussed, and that's one of the issues which the EPSU raises in the hearing, why did the Commission refer to the exercise of public authority? My suspicion is that it's an implicit reference to Article 45.4 TFEU, which says that, and that's the somewhat strange thing about the difference in language versions. In the English language, Article 45, may I remember, is about free movement of laborers. And Article 45.4 says the provisions of this article shall not apply to employment in the public sector. But in the French or Italian versions, it's not employment in the public sector, it's public administration. And as we know, in the Commission, people are used to work in different languages. So what I think is that one should be clear, and I'll come back to this, about the difference between the functions of central government administration and other reasons of the impact of EU law. Now, as far as organization of central government is concerned, well, the Commission in its letter said it's very different from one member state to another. There are federal states, unitary states, and thus for the Commission, central government functions are exercised in very different ways in different member states. Yes, but also in a unitary state, there are so-called departmental organizations which are under the hierarchy of a minister and arm's length agencies which are autonomous. So the diversity is enormous, but I think it's not as such relevant to the issue here. It's not because there's diversity that there should not be social dialogue in all branches of government. Now, if we take a second point, which is the member state administration and organizational autonomy and applicability of EU law to central government administration. Here it's also because the Commission says, well, member states are free to organize themselves. Yes, they are. It's a consequence of the principle of conferral. Member states have not delegated to the EU the power to decide upon their internal organization. Furthermore, Article 40 EU explicitly states that the union shall respect the fundamental structures inclusive of regional and local self-government. Is this relevant? Well,
we have no sound. Il n'y a pas de son de l'orateur.
Yeah, we lost Professor Diller. Sorry, we lost Professor Diller. We don't hear Professor Diller. We will check with our technician how can we solve the problem.
Monsieur Diller, on ne vous entend plus. Yeah.
Professeur Diller, il faut allumer les microphones encore. Donc, si vous pouvez allumer les microphones.
Qu'est-ce que je peux faire?
He doesn't hear us. Il n'entend pas nous, je crois.
Est-ce que je peux intervenir? Non.
C'est vous qui contrôlez Teams? Vous pouvez activer son micro à distance.
Okay.
C'est vous qui avez coupé le...
Est-ce que vous pouvez le faire? Parce que je ne sais pas comment.
Là, on voit que son micro est coupé à côté de son...
Oui, mais...
I'm hearing a lot of things, but I'm seeing nobody.
It's good now.
Yes, but can we say?
Did you hear me?
On vous a perdu pour 5 minutes.
Thank you.
Professeur, je crois que maintenant on vous entend, donc si vous voulez continuer.
Oui, rattraper.
It would be good if I were to know where you stopped hearing me.
I think you were talking on Article 45.4. So
all right.
You were
so
on
I'm
that
sorry,
side.
the technology is not functioning very well. I'll get back to where I was then. All right. Just a moment. You should be seeing my PowerPoint again.
Yes.
Yes.
All right. So what I was saying is that my suspicion is that the reason why the Commission in its answer to EPSU was referring to the exercise of public authority was something which is not relevant to our case, which is the jurisprudence on free movement of laborers in the public sector. Now, functions of central government administration are extremely diverse and certainly not limited to exercise of powers of public authority, but also the organization of central government is extremely diverse. And indeed, that's what one of the points which the Commission was making. There are federal states, unitary states, and central government administration would not be the same. To me, it's not a good reason, because also in unitary states, there are differences between departmental organizations under the hierarchy of a ministry, minister, and agencies, arm's length agencies which enjoy a very large managerial autonomy. So the whole point is that there's a very big diversity in member state administration regarding functions and organization of central government, but this is not, to my idea, a reason not to have social dialogue organized in the same way for central government in all member states. Now, the second point which I wanted to make is a reference to member state administration and organizational autonomy and the applicability of EU law to central government administration. Because that's another point which the Commission has been making, saying, well, member states are free to organize themselves, and that's, in a sense, a reason why we don't think that it's appropriate to ask for the extension of the agreement on social dialogue. Now, it's true that there is the principle of conferral, which is central to EU law, as we know, which means that member states are fully autonomous, and the member states have not delegated to the EU the power to dictate how to organize itself. But, and that's the central point, there are numerous exceptions to this principle. There are exceptions in the treaty where there are provisions which impose the existence of a certain type of local government, but that's not the most important. There are extremely numerous exceptions in secondary law. Just think about the very numerous directive regulations which impose to member states who have to have specific organizational structures. Think about the GDPR, which imposed to member states to have independent bodies which are responsible for the whole question of protection of data. But furthermore, there is a very important jurisprudence of the Court of Justice on procedural autonomy, which applies also to organizational autonomy. And this jurisprudence is centered on the principle of effectiveness and equivalence. What's important here is effectiveness. Member states have to organize themselves in order to comply with EU law. So, and I'll finish here, my central point is that there is a very big differentiation between member states as far as the organization and function of member states is concerned, that this is not, to my view, a reason to not have the same kind of provisions for social dialogue amongst all member states. Thank you very much for your patience. I hope that this time I've been heard. Thank you.
Thank you very much, Professor Diller, for this very useful presentation. Now we have Jean-Paul Tricard, that is here present in the room. He works for ETUI, but he used to work for several years for the European Commission in the Directorate General for Employment, Social Affairs and Inclusion, and in particular he was from 2008 until 2014 the head of unit for social dialogue and industrial relation. And he wrote recently a very, very useful working paper published by ETUI in order to present the legislative implementation of European social partner agreements, challenges and debate. And it's very useful because reading this paper we can really understand the context and the atmosphere inside the Commission, and it clearly mentioned as a turning point the 2012 as a year in which we have a change. So please. the technical recommendation, I repeat, the technical recommendation, people from home that don't speak, please close your microphone, because if not, we hear a background that is not nice to hear. Thank you.
Okay, good morning, everybody. Thank you very much for the invitation. Thank you very much also to the organizers for having taken the initiative of organizing this meeting. I think that it's extremely important because, as it has been said, the EPSU case is not only relevant for lawyers, it's relevant for the future of social dialogue in general and of EU social policy in general. Just 1 minute. Try to see. Yes. I present today a paper which only represents the view of the author. This clause is a rather standard clause, but I want to highlight that there is a very specific reason why I said that I does not commit the institutions in which I have been working in the past, and in particular the European Commission. It is that the paper that Sylvia referred to, which was published last year, was the subject of the controversy with the Commission, who tried to block the publication on the ground of the status of civil servants. So I want to say, when I highlight this is an independent view, that yes, I certainly don't represent the views of the institution. It is part of a wider work that I am doing within the ETUI. By the way, I am a researcher by background. I was a sociologist in France in the National Center for Scientific Research before joining the Commission. So I have been working with the Commission for more than 30 years, but now I am back to my position of researcher. So, no, sorry, I have missed something. Yeah. So the purpose of my presentation, as I want to highlight that I am not a lawyer, I am not a legal expert, so I try to consider the court ruling from the point of view of the history and the developments of social dialogue, taken from the point of view of the actors of social dialogue. And when I say the actors of social dialogue, I will insist very much on this. It is the social partners, but it's also the EU institutions, and I think that this is something important. And I therefore question the court ruling from this point of view, in particular the history of social dialogue, the conditions of its invention, the conditions of the definition of the rules of operation of social dialogue, the treaty provision, the use of the provisions of the treaty, and the conditions of deterioration of the relations between the Commission and social partners about these provisions. If I highlight these elements, it's because these elements are missing, in fact, in the court ruling. So to some extent, I am more attentive to what is missing in the court ruling than to what is in the court ruling. Of course, I can make some comment on some of the points of the ruling, but what is for me important is to highlight that to some extent this ruling misses what is social dialogue at EU level. I refer, of course, to the study which was published by ETUI last year, but I want also to highlight that I produced another paper earlier this year, in the annual report, which is coordinated by the European Social Observatory, which is this report, Social Policy in the EU. So you have another paper on EU social dialogue in this note. I come now to the conditions of invention of European social dialogue. I am obliged to go rather fast, but I want to highlight a few key ideas. First of all, EU social dialogue is a joint invention by the Commission and the social partners. It was right from the beginning, even before the Delors year. If we go to the prehistory of social dialogue, it means the report by Gérard Lioncan in the 70s about the possible future of a European collective agreement. There was already this idea that if the Commission does not come in the play, there will be nothing. Because it's not possible to have the start by the workplace, then the branch, then the local, and regional, and the national level. It was not a bottom-up process. It was a top-down process to some extent. It means a layer has been added to what existed at national level. So this is also why I say it's fundamentally tripartite. Saying this does not mean that I underestimate the developments of bipartite social dialogue, which, by the way, mainly took place later on the basis of the tripartite. But it is tripartite. So what it means that the Commission is not external to the system of industrial relations. We have to think a system of industrial relations. We are not in the approach which underlies the court ruling, which is that social partners are some group of interest or some lobbies which are trying to influence EU policies, and the Commission is acting on behalf of the general interest in order to balance and define policy which takes into account or not of the social partners' views. By the way, the court expressly says that precisely the power of assessment of initiative of the Commission is based on the fact that it represents the general interest and that social partners don't represent the interest. Here it was the contrary. First, the Commission is not external. To some extent, the system delegates in the specific area of labor law relations and labor law issues under Article 153 of the treaty, the possibility for social partners, because they are both those who will receive the benefits but also bear the cost of any measure which would be taken under Article 153, they have a full capacity and full responsibility, accountability for taking decisions. There is no need to call for other actors. And by the way, this is also why in the assessment of an agreement between the social partners, a key element is that it is impossible for the social partners to agree on positions which would imply cost for others than employers and employees. So, because in this case, of course, they go beyond the scope of commitment that they can legitimately take. So this is the promotion of social dialogue is not external. It's the Commission is part of the system, and the court ruling missed, in my view, this point. The consensus on the rules of the game. We can see the EPSU case as a kind of final step of a game to some extent. What does it mean? It means that EU social dialogue has been established by the treaty when there was the adoption of the article of the treaty at the time of the social protocol, of the agreement which was attached to the protocol and to the Treaty of Maastricht. And after the adoption of these provisions, there was a setting up of some rules, how to operate And this was done by a joint work by the Commission and the social partners, exactly as the IGC had delegated to the social partners the task of drafting the text of the provision on social dialogue in the treaty. This is also something which is ignored by the ruling. There was a suspension of the work of the IGC in order to wait for the text coming from the social partners during the IGC in 92. And afterward, the communication of the Commission in 93 was elaborated further to an intensive cooperation between the social partners and the Commission. To some extent, the Commission communication builds on contribution by the social partners. And the spirit was defined in this initial phase, and this is why the communication 93 is important, in particular with regard to the statement on horizontal subsidiarity and the statements on the mutual confidence and trust between the players. And with regard to the rules of the game, the criteria and conditions of legislative implementation of the agreements are also defined in this communication, with, in particular, the criteria of representativeness and legality check, which are now also still in force. And here again, we can highlight a problem in the court ruling, which is the court disregard the communications of the Commission of the 90s on the ground that they have no legal value. But in fact, it continues to refer to the criteria of legality and representativity, which are not in the text of the treaty, but which are in the communication and which were set precisely by these communications. The communication of 98 continues to be the reference in any text which is presented to the Council. There is always a recital which says that the Commission has assessed the social partners agreement on the basis of the criteria defined in the communication 98. So it's not only something which exists for the Commission or the social partners, but also for the Council. And this communication is very important because it explicits a clear rule, which is that the Commission has to use the criteria of representativeness and of legality, but there is also the fact that with regard to appropriateness, there is a clear distinction between agreements which have been concluded further to a consultation or outside the consultation. If it is further to a consultation initiated by the Commission has already taken position on the appropriateness of community action. So it has not to reconsider this once the agreement is concluded. On the contrary, appropriateness has to be considered by the Commission if the negotiation is concluded outside. So all these elements which explain why during 20 years it was possible to operate, and a number of agreements, some 10 agreements in the period were concluded and transposed into EU legislation according to a system of extension which exists also at national level, by the way. This was done without major controversy. The controversy with the UAPME case is not linked to the problem of operation of the treaty provisions. The situation deteriorated as from 2012, I will say, as from the Barroso II Commission. Basically, the reason is that the Commission did not want to continue to use the legislative instrument, in particular in the social policy area, not only in the social policy area, also in some other areas. But in the social policy area, the problem was that most of the new proposals came from social partners' agreement. So if you compare the number of proposals which are based on Commission initiatives only or on social partners' agreement between the period before 2010 and the period after, you have a huge contrast. As from 2010, I will say, more than half of the Commission proposals in the social policy area come from social partners' agreements. So it means that if the policy of the Commission is to try to limit or even to stop the production of new legislation in social policy, it is necessary to dry up the source of legislation coming from the social partners. And this is the reason why, as from this period, there was an increasing concern about these agreements, and to some extent the crisis, which was mainly the mediatic and political campaign about the agreement in the hairdressing sector, came as, I will say, an opportunity to raise the overall question of what to do with this procedure of Article 154-55. I can say, because I was part of those who were involved in this debate at the time, that until the failure of the negotiation on working time, which protected to some extent the treaty provisions until the failure, when it was clear that there would be no proposal coming from the social partners on the revision of the working time directive, and that there were only sectoral agreements, the pressure for revisiting the rules of assessment of the social partners agreement became extremely strong internally. And this is why it was decided to have impact assessment rules. This is why it was decided to have new forms of assessment and even to treat the social partners agreement as if it was ordinary pieces of legislation. By the way, afterwards the Commission said that this is not a legislative procedure. I want to say this is a point which will be discussed later on, of course, but I have to say social partners were never kept informed that there was a possible debate about this question of the nature of the procedure, legislative or not legislative. This is something that even between the legal service and DG Employment in the Commission was never discussed at any time. It came really later on, but I don't want to go in details. Under the Barroso Commission, of course, we had this deterioration, which culminated in the EPSU case. I want to highlight that in the EPSU case, there were the two dimensions. Is the Commission authorized to say no to an agreement? In the agreement of EPSU, it was the first consultation, because since the Lisbon Treaty, it was possible to open negotiation after the first consultation. But it had been preceded by a very important refit exercise. So to some extent, all the questions which were on the table, which generated the negotiation in this particular sector, were already raised. When the Commission afterwards said that finally there is no possibility to operate in the area of public administration or central administration, all these questions had been discussed in another sense during the refit exercise, which had a duration of 2 years. And secondly, there is a problem of the Commission attitude, which phrased for 2 years the assessment of the report. And here the court ruling considered that the attitude of the Commission, it is said, which is rather strange, the attitude of the Commission could be surprising, or could be considered as surprising. But the problem is that it paralyzed this point of the ruling, paralyze also the future. Because if normally when there is a crisis, such as a crisis generated by the court ruling, the response of the institution is a Commission communication in order to say, we need now to try to find a way of operating together. But the Commission the court has said that the Commission communication have no value, and that, by the way, even when the Commission is openly lying, it is part of its power of initiative, and nothing has to be said against. So to some extent, we are facing a total blockage with regard to the follow-up. And this is why I say that there is here a huge danger, because even if there was within the Commission a will to find a way out, to some extent, the main instrument for doing this have been by advance undermined by the court ruling. This is why, to some extent, at least it should be important for the court in this appeal procedure to reconsider and revise those conclusions. It is clear for me that if the Commission now considers that it can abstain from participating in the system of industrial relations at EU level, it is the end of social dialogue as it was invented. Because it was a tripartite system and so on. If the social dialogue is deprived of this component of collective bargaining, it is also the end of collective bargaining, of social dialogue at EU level as it was invented. And this is also a debate for the social partners as a whole. To some extent, the question is that it would be better, of course, to come back to the 98 criteria. In this case, it would be relevant to consider the agreement concluded in the sector of central administration, maybe to have a debate about the way, and this could be a political solution, the way we consider to incorporate or not the question of the regional and local administration in order to cover the public service as a whole. It would be a way to try to find a compromise. But the problem is that for the time being, everything is paralyzed and suspended to the appeal procedure before the court. I will stop here and I will be pleased to respond to any question. Thank you.
Thank you very much to Jean-Paul Tricard. And now we have the presentation of Philippe Dosserman. Philippe does not need any presentation, at least not in this field, the European Social Dialogue. He is full professor at the Law Faculty of University Louvain-la-Neuve. He has already written a comment to the first decision, to the decision of the General Court. The comment will be published in English in a collection edited by the University of Lund, and it will be published in Italian on the next issue of Lavoro e Diritto. Thank you very much, Philippe.
Thank you, Silvia. So I will speak about something which is purely technical, aesthetical, that is the hermeneutics applied by the General Court. Now, what is hermeneutics? In essence, it is just the way to interpret, the method to interpret something, in this case, constitutional provisions of EU law. So I will try to see how the court interprets EU law, or rather, how it pretends to interpret EU law. Whether it is actually doing what it is promising is quite another issue. And in order to have a better understanding of what the court is doing, I will confront this with the Vienna Convention, not the convention which was concluded when Napoleon was defeated, but the Vienna Convention on the Law of the Treaties of 1969. And to be very quickly, I will produce a scheme to compare these two approaches. Under the Vienna Convention, you should, of course, identify the ordinary meaning of a text, but not in an isolated way. You should find that ordinary meaning in the light of context and purposes. Now, context in the Vienna Convention does not mean the historical context, which was very nicely explained by Jean-Paul Tricard. It means the textual context, okay? Within the instrument or within other instruments, but concluded relevant for the same parties. We are not in a Demir and Baicara scope of large intertextuality. So context means intertextuality. You also have to look to objectives, insofar as probably they can be identified in the text. And only when that does not work, you can have recourse to what the English so nicely call the travaux préparatoires. Now, this Vienna Convention is, of course, strictly speaking, not relevant for the EU as EU, but if you look to the convention, it's clear that it is relevant for treaties. It is relevant for constitutional treaties, and it is customary international law, which as customary international law should be relevant. This does not preclude that the EU derogates from this customary international law. Even if the convention is formally applicable, you can. But I think it sets a conceptual benchmark, which enables us to better understand what the court is doing or pretending to do. What does the court do? The court says, well, we'll look to the ordinary meaning of the text. So it's the first plea, Article 1552, TFEU. But we will look to it in the light of the travaux préparatoires. That's very strange, because in the logic of the Vienna Convention, this is really a default interpretation. If the interpretation, the normal interpretation, is absurd or obscure. And then it dissociates that ordinary meaning from a contextual interpretation. But what the court is doing, it is actually only comparing Article 1552 with one provision. Not even a provision in the title on social policy, but somewhere else, in the very general text, another treaty, the TEU. It is disregarding all other relevant provisions which are part of the context. This is not a critique, it's just an observation. And then there is the purposive interpretation, which is also dissociated, and there only one article comes into play, Article 152, which is about the promotion of the role of social partners. And then a box is created, an unseen box, other arguments, miscellanea, other arguments, and these are actually all the arguments which the court refuses to integrate in the contextual interpretation, in the purposive interpretation, although it's very obvious, in my view, that they are part of the context and that they enshrine purposes or objectives. Now, so if we look to what the court calls the literal meaning of the text, okay, literal interpretation, the court does something very strange. It says, okay, we will give a kind of literal, grammatical, lexical interpretation, and on the basis of this, the words shall be implemented means the opposite of a literal interpretation. It means may. And it does so by invoking the travaux préparatoires. But if you take the travaux préparatoires, it is exactly the opposite, because the may, which was timidly, modestly proposed by the social partners, they are timid and modest, was replaced by a stronger shall. And the result of it is that you come up with a text which is actually poetry. It is like a text saying, tomorrow it can be good weather or it can be bad weather. That's true. But it's not the kind of thing you should put in a legal text. So they come up with an interpretation which makes no sense, because from this Article 1552, no obligation at all arises for nobody. And this makes this interpretation absurd, in my view. This is not a critique, this is an observation. And then we have the contextual observation, which is really limited to Article 17, the EU. Article 17 is about the powers of the Leviathan. It is about the machinery. It is not what my friend Fotis Vergis would call the substantive issue of the values, of the rights of the citizens. It is about the machinery of power. And that Article 17 is being interpreted, well, in a way which is puzzling to me. Article 17 is about pushing European integration. It is about a commission taking initiatives. And it is used in a context where the commission stops taking initiatives. I'm also puzzled because in this context, but I will not draw on that, the court is suggesting that this decision of which the Commission proposes to implement agreements is not a legislative act, whereas I have read, I think in Gatse, the Gatse judgment, great judgment, that actually there is no difference at all between an ordinary directive and a directive implementing an agreement, at least not for the sake of, interpretation. And I will not talk about the use which the General Court makes of the WEBINAIRE judgment, because that is very bad for my blood pressure. But then there is also the teleological interpretation, purposive interpretation. There, the court only deals with Article 152, whereas you have a promotional language, a purposive approach in Article 151. That is the apex. These are the opening bars of the title on social policy. How can you miss them? The court is also ignoring, in this part of its judgment, Article 28 of the Charter of Fundamental Rights, the Bill of Rights, which should protect the citizens against the Leviathan. Because I must remind this, if you read the Charter, it clearly states in Article 5.1 that the EU, this includes the court, is to promote the rights, enshrined. So there is scope to say we should include Article 28 in this purposive part. It does not. Okay. The other arguments, I think they should have been indeed integrated into this purposive and contextual approach. I cannot flesh them out here, but these were interesting ideas, notably Article 28, the notion of subsidiarity, horizontal subsidiarity, which will be dealt with. And, oh yes, I always forget about it. Democracy, of course, democracy. Social dialogue is an element of democracy. Read the Constitutional Treaty, remember, where the social dialogue was explicitly seen as an element of democracy in the beginning of that Constitutional Treaty. Furthermore, in WEBINAIRE, the court says that the social partners, the social dialogue, is a valid alternative, not a threat, as this Jacobin judgment tells us, not a threat to democracy, an alternative. Okay? Conclusion. Okay, conclusion might be that I think this literal interpretation is a kind of literal interpretation as we never heard of, because it says something, means the opposite in a literal interpretation of what it means. You have a kind of treatment of the travaux préparatoire, which is puzzling, and I would say what the court is saying, okay, this is not legislation, is the opposite of the big thesis of Antonio Lofaro. Lofaro said, this is not collective bargaining. This is a manipulation of social partners for the sake of legislation, what the French call négociation légiférante. Here the court says exactly the opposite, and it's completely at odds with, I'm not saying the intertextual context, but with the historical context of the social dialogue. Okay, I think that I see the boxes, I don't have a problem with the boxes, but I think that the content is not up to the standard of the boxes. In fact, I've used these boxes in an article with Melanie Schmidt, with Klaus Löscher, but this is where the comparison stops. between that article and the judgment of the court. And I would like to quote, because Silvia is next to me, a famous Italian, okay, who in another context said about another judgment that the judgment was, had the potential to alienate from the single market and the EU a segment of public opinion, workers' movements and trade unions, which has been over time a key supporter of economic integration. This was, of course, Monti speaking about Viking Laval. You might have heard of these judgments, but I think this is applicable to EPSU as well. I will leave it there, Chair.